All right. Thank you, everyone, for tuning in. This is a presentation. It's going to be about 25 minutes. Special education law. What is going on in the country and what are our guidelines as of February 2023? I'm going to talk a lot about some major laws that govern special education. As we go through this presentation, I want to kind of implore you to think of this as education law. There is nothing in special education law that separates children who receive special education services. We are pushing for more inclusivity in 2023, and so I want us to think, though the name of the department in school is special education, I want you to think of this as just education law. February 2023, let's get into it. So today, just as a quick agenda, because if you are an educator, you know that it is impossible to learn without written objectives and an agenda. I kid. But I'm going to give you an agenda anyway, just so you know what to expect for the rest of the presentation. I'm going to start with some opening remarks. I'm going to talk through a case that is currently pending in the Supreme Court to kind of frame the rest of this presentation. And then we're going to go through a timeline of history of the special education laws, kind of starting way back into the 1800s and the treatment of students with disabilities back then, all the way to up to where we are now. And then we're going to just summarize the big three guiding laws. There are three of them that guide special education laws in public education today. We are going to do a deep dive into IDEA, which is the Individuals with Disabilities Education Act, and look at specific school district responsibilities. What are the things that your district is responsible to providing your child? And then we're going to talk about the membership of the IEP team. IEP stands for Individualized Education Plan. We will go through that in detail under the school district responsibilities. As well as the contents of an IEP. So not only the team who comes up with the individualized education program, I might have said plan before, the specific verbiage is individualized education program. And then the IDEA law actually requires some mandatory minimums for the contents of an IEP. We'll go through that as well. We'll talk about student discipline. And then how IDEA defines a child with a disability, kind of ending with how, because I am in the state of Colorado, ending how state laws can impact your school district's specific responsibilities. The ECEA is the Colorado state law that aligns with IDEA. So that is the Exceptional Children's in Education Act. That came out June 2022. So I'll talk a little bit before we end about what it's like in Colorado today. Let's get into it. So today in special education law, I want to talk about Miguel Perez. His case is currently pending in the Supreme Court. What happened to Miguel here is Miguel was a deaf student. He immigrated from Mexico. He went through Next up, we have the timeline of special education law. I'm going to go all the way back to the 1800s. Here on my screen is a newspaper article. I want to give you a little bit of background on myself. I myself am dyslexic and dyspraxic. I really struggled in school. I am very passionate about inclusive education in general education. And so if a child in the 1800s was not able to keep up with public education, we would have gone to an asylum for the deaf and dumb. This came from 1829. Dumb in this day and age is a horribly ableist term. And I implore you just to kind of think about where we were back in those days. This is what the treatment of disabled children looked like. Flash forward then almost 100 years. Well, I'm not very good at math. 1973. We have the Rehabilitation Act. Section 504 specifically addresses special education. The Rehabilitation Act itself was not just solely about education, but it defines individuals with disabilities as having an impairment which substantially limits one or more life activities. Section 504 of the Rehab Act specifically addresses exclusion of those with disabilities. So in 1973, exclusion was outlawed. And then in 1975, we have the Education for All Handicapped Children Act of 1975. This was the law that actually kind of morphed into IDEA. This was the start of IDEA. Prior to that, only 1 in 5 children with disabilities were receiving an education in public schools. And prior to that, too, states were permitted to exclude deaf, blind, emotionally disturbed, or intellectually disabled children from public schools. This law in 1975 proposed that all schools receiving federal fundings were required to provide equal access, which aligned with the 1973 Rehab Act, Section 504. So again, no more exclusion. However, if we flash forward to 1990, if we go all the way back to the Civil Rights Act of 1964, previously, individuals with disabilities had no recourse. So the 1964 Civil Rights Act didn't specifically address physical or mental disabilities, and so individuals had no recourse if we needed to sue for discrimination. Unlike discrimination based on race, color, sex, or origin, physical or mental disabilities were not addressed up until ADA, which specifically said physical or mental disabilities in no way diminish a person's right to fully participate in all aspects of society. That is so, so important. We have the amendments in 2008 of the ADA law. So in 1990, the federal law didn't do enough for states to consistently interpret the way that disabilities were defined. And so the implementation of ADA and the way that it was treated in courts was inconsistent throughout different states. And so the amendments in 2008 kind of helped to refine the federal definition of disabilities. While Congress expected that the definition of disability under ADA would be interpreted consistently with how courts had applied the definition of a handicapped individual under the Rehab Act of 1973, that expectation had not been fulfilled. So the 2008 amendments of ADA did a lot more federally to define disabilities. So in 1990, we also see IDEA. IDEA is the first time we hear free and appropriate education for all. I will abbreviate that as FAPE, F-A-P-E. Again, I will go into details in IDEA later in the presentation. Just know that it was amended in 2004. Again, with more kind of definitions of how states can interpret the IDEA law consistently. We are still having issues with consistency today. I'll talk more about that later as well. 2004, the amendment said that disability is a natural part of the human experience. Amen. And it no way diminishes the right of an individual to participate in or contribute to society. Improving educational results for children with disabilities is an essential element of our national policy of ensuring equality of opportunity, full participation, independent living, and economic self-sufficiency for individuals with disabilities. Yes. So that is where the IDEA gives us. That is the guiding concept of IDEA, is that we have now, it is in our national policy to ensure equality of opportunity, full participation, independent living, and economic self-sufficiency. I truly believe that that begins with a free and appropriate education. So that brings us to the big three then. We have three big guiding laws in education that touch on special education. We have the Individuals with Disabilities in Education Act. This is going to be our big guiding North Star. We have the Americans with Disabilities Act. Title II specifically is what addresses education. Americans with Disabilities Act, another federal statute with IDEA. It is kind of our overarching law on Americans with disabilities in the United States. And then we have the Rehab Act specifically Section 504, the Rehab Act of 1973. Again, aligns with ADA, aligns with IDEA, talks more about exclusion. Now, going back to IDEA, we're going to do a deep dive into the district responsibilities of what IDEA proposes for our district. As some background, before we dig into the specifics, IDEA proposes that we as states, or I say we, states need to ensure that their school districts are ensuring substantive and procedural due rights for all students, including students with special education services. Again, I don't like to say students in special education. That that's kind of separatist language there. So we say students with an IEP, not an IEP student. Just as a little side note, if we are going to be talking about ableism, language is important there. Substantive rights. Substantive rights are like the meat and potatoes of special education. That is what the child is actually getting. That is specially designed instruction. It is their accommodations. It is their pull-out, push-in services. It is everything that governs what is included for a free and appropriate education. And then procedural due process talks about how it's delivered, timely evaluations, membership of the IEP team, kind of ensuring that all of the procedures in special education are being met with fidelity as well. So substantive rights are the what, and procedural is the how. Another kind of big plan under IDEA is that every single school district needs to have plans to ensure that they are meeting those substantive and procedural due process rights. Those plans must be made public. I do want to talk about a case before we go into kind of functional exclusion, which should be, I did reverse that. So Timothy v. Rochester actually was a early case in IDEA. Timothy W. Was blind. He had an intellectual disability, and his school district ended up deciding that he would not benefit from special education services. So at first they refused to serve him in public school. That was a no-go. The courts decided that no child is to be excluded from a free and appropriate education. And this is where we see the introduction of, we need to be teaching in schools. Life skills and functional skills are a part of a free and appropriate education. So now schools are no longer just responsible for academic skills. We are responsible for teaching functional life skills as well. And this comes in the form of an individualized education program. If we deem a child is eligible for special education services, they will receive a individualized education program, or what we call a 504, or what we call a BIP, which can be included in IEPs and 504s. There's a lot of acronyms we will go through. IEP, Individualized Education Program, is the one to know for now. There's functional exclusion. That's what I was looking for. We talk about in IDEA, we talk about least restrictive environment. The least restrictive environment, or the LRE, is a huge one to ensure that the child is included in general education as much as possible. The least restrictive environment has absolutely nothing to do with physical restrictions of where the child can go in school. A child with an IEP has every right to be anywhere in the school building. It is not just the fact that children, once they receive special education services, they go to a separate classroom. They may do in some cases, but that is not the idea of a least restricted environment. It is named so in IDEA because it has to be the environment where they're least restricted from receiving their free and appropriate education. AKA, the least restrictive environment is the environment where they are most successful. And another term on that same note is functional exclusion. Functional exclusion occurs when the placement of the child is not appropriate and they are not receiving their free and appropriate education. Therefore, they are excluded from receiving their free and appropriate education. That can look like anything from inappropriate IEP accommodations, inappropriate placements, et cetera, et cetera. The big responsibilities, we're going to take a deeper dive into some of the bigger responsibilities now. Response to intervention, I'm going to throw up the MTSS slide as well. So multi-tiered support system is kind of the first step in identifying children with disabilities. And there is some provisions in IDEA that say prior to kind of designating a child as learning disabled, they must be shown to have not responded to instruction that is differentiated, high quality, research-based, multidimensional, and data-driven. I do believe this is important in responding to a child that you suspect may have a learning disability versus a child that is just struggling in one area. These are two different things. And so there is a caveat with response to intervention and multi-tiered support systems, is that they do not take place of evaluations and they do not halt any evaluations. If you suspect a child has a learning disability, do not wait, evaluate. However, a response to intervention is very important, because what if there is a child that is just struggling and there ends up being a skill deficit, not necessarily any requirements for special education. And so response to intervention and multi-tiered support systems are put in place to nip those in the bud early, and to really kind of define if a child is required to have special education services or they need specialized instruction in one area in order to succeed. And so again, the goal is not, I said it's, well, I didn't, this isn't my words, reduce the number of children categorized as learning disabled. This is not something that districts will always use to save money. It is not some kind of like horrible halting, we are not going to evaluate your child. That is not what MTSS and RTI is for. It is to nip those skill deficits in the bud early on. Some more district's responsibilities then, after we have identified a child is in need of special education services. There's also some verbiage in IDEA, the federal law. This one's actually taken from the ECEA, which directly aligns with the IDEA law. And it says assistive technology. If there is a child that needs assistive technology and is receiving special education services, training or technical assistance for any professional working with that child needs to be provided by the district. I thought that was very interesting. And also IDEA talks about related services. So we talk about special education and related services. Going back to the Timothy W. v. Rochester case, the child in that case needed simple medical services, which can be done in schools. Schools are required to provide simple medical services. We have a lot of children with diabetes in school that need assistance with insulin, that kind of thing. The IDEA law actually says anything that's non-surgical, which goes into kind of leading into occupational therapy as well, and speech language pathology. These are related services that must be required in schools. Occupational therapy only to the extent where it's non-medical. Again, anything non-surgical. Occupational therapy can look like even simple classes that teach students how to use the accommodations that they are entitled to. So related services are important in schools, and it is the district responsibility to provide those. And if they are not able to provide those, then the schools can opt to provide funding for a private placement in order to ensure that the child still receives a free and appropriate education. Obviously, it's not free to the district. A free and appropriate education is a child's right, and if a school district cannot provide it, they can be on the hook for providing private placement funding. Moving on. So, who can be on the IEP team? This is actually dealt with in section 300.321 of the IDEA federal law. I want to start with the most important member of the IEP team, wherever appropriate, the child with a disability. I know there is some contention, like how old does the child have to be to sit in a meeting? There is no minimum age in an IEP. And there is no maximum age. So any child, where appropriate, can have the right to sit in their meeting. Obviously, we want to make sure it is appropriate for them. If the verbiage and idea specifically states too, if a child does not attend the IEP meeting, we must respect their interests and wishes as well. However, the most important person in the IEP team is the child with a disability themselves. I attended my own IEP meetings when I was starting at age 16. Had I known that had I known the kind of gravity of those IEP meetings, I definitely would have gone earlier. It just wasn't something that school-age children are really taught. This is where self-advocacy begins. I don't see that happening a lot in schools. I think transition ages and transition services are so important that we need to start pulling children in, at least to portions of their meeting when we're talking about accommodations. That can start in elementary school. Have at it. Teach your child to self-advocate as early as possible. Enough of that. So, parent and guardian. Obviously, equal member of the IEP team is the parent guardian. I would like to add that every single member of the IEP team is an equal membership. It is a partnership between peoples. It also has verbiage for at the discretion of the parent guardian or the agency. So if a parent guardian wants to bring an advocate, wants to bring a friend, anyone who knows your child, knows what services are going to benefit the child, even the school district can bring in another party to discuss that as well. Advocates are not just hired by parents, remember that. And including transition services, yes. So that's a big one because once a student reaches the transition age, there's going to be a lot of related services that talk about what happens after they graduate. And so members of the transition services team should be absolutely included. At minimum, they need to have one general education teacher. The 2004 reauthorization of IDEA does exempt a gen ed teacher with parent guardian permission. There's other caveats that need to be involved. I would not recommend having a gen ed teacher step out of a meeting. There is no reason for that. I think the gen ed teacher is a much required and again equal member of the IEP team, especially in the inclusion world we are living in. Of course, the special education teacher needs to be included. And then we have an admin that needs to be included. It does not have to be the principal. It can be a delegate of the school. It needs to be somebody that has the authority to say, to designate resources, not an authority to say yes or no to resources, because, I mean, who would say no if the child needs something? And then we also need to include other service providers. It is an individual who can interpret the instructional implications of evaluation results. So other service providers can include a speech language pathologist, a school counselor for maybe behaviors, a school psychologist, an occupational therapist, the school nurse, anyone who provides other services to the child needs to be included. Another caveat here is that these are roles that need to be filled at a IEP table. And so if the special education teacher happens to be the special education director that has the authority to provide those resources, then they can be filled by the same person. It can be an admin and a school psychologist who is the admin. If the admin can't show, they need to send a delegate, basically, and it needs to be a person who can provide the authority to say yes to those resources, basically. So at minimum, parent or guardian, gen ed teacher, special ed teacher, admin, and other service providers. And again, those roles can be filled by multiple people as long as they have the qualifications, certifications, and everything necessary to fulfill those roles. The IEP mandatory minimum requirements. I'm going to pull all of this up here. The link to this YouTube, I pulled an example from Mississippi here. Mississippi, the Office of Special Education under the Department of Education has developed a full kind of IEP development guide. Although IDEA is a federal mandate, it provisions for states to take responsibility in ensuring that their school districts can meet the minimum requirements in the IEP. At minimum, IDEA says that an IEP needs to include present performance levels. This includes test scores, any relevant data, behavior cycles, anything that gives a description of where the child is at in order for the IEP to be written. This is kind of step one. We need the present performance levels so that we can write measurable goals. These measurable goals include functional goals, which can be managing their own behavior. We need academic goals. We also need, in that statement, we need a description of how the goals will be measured. And that's a highly important content piece of the IEP. And then we have a description of services. The description of services in the IEP needs to talk about specialized services and specially designed instruction. This is going to be like the how the student will meet those goals that are listed. And there needs to be a description of where the student will be educated, as in the least restrictive environment. So it needs to include a statement of how much time the student will spend in either a self-contained classroom, if that's going to be where they are educated for part or all of their time. It needs to include a timeline of when there will be pull-in, push-out services. And then lastly, it needs to include a description of accommodations and any modifications made for academic work. That can include test-taking accommodations, extra time. It can include read-aloud proctors, and then any modified assignments. So in the IEP, something that's very common that I do for students that do have this accommodation on their IEP, if I set some classwork assignments and they have 10 problems to work through, maybe I will star the most important 4 questions. I want you to do these 4 questions instead of the 10. That is their modified assignment. Any rest breaks or fidgets, and any other provisions that will provide any accommodations or modifications to ensure that they're receiving their free and appropriate education. Discipline. So IDEA makes a lot of fuss about discipline for good reasons, because all students have a right to procedural due process. If any student with an IEP or without an IEP gets in trouble, I believe that they should have that right to speak for themselves. Before we take any discipline, we need to hear their side of the story. That's kind of the same idea with IEPs. There's just a lot more regulations on how that can be done. If any student with an IEP breaks the school code of conduct, we need to have a manifestation determination. Is that behavior caused directly by their disability? Is it a manifestation of their disability? Did a student choose their behavior? I know a lot of students that do have emotional disturbances. I was one of them. We don't want to act out. We don't want to be that way. We don't choose disabilities. And so this is why manifestation determinations are so important. It is illegal to discipline a child for a disability and for a behavior that is manifested in that disability that they did not choose. That is just, not only is it unfair, it is inhumane. So we have some stay put regulations. In 1997, if a student with an IEP or a 504 or any behavior plan with any kind of disability, if they act out in the classroom and maybe damage a piece of school property, back in 1997, we were not able to take them out of that classroom prior to a manifestation determination. And now we can. We can place the child in a new setting or a new placement as long as there is a manifestation determination within 10 days. If not, they're breaking the law. Expulsion and suspension, this is very kind of clear, and I'll talk about isolation and restraint as well in the same kind of thing. Expulsion and suspension, any student with an IEP or any kind of behavior plan is not exempt from school discipline, especially expulsion and suspension. They just have to go through that procedural due process, which includes manifestation determination. There is actually a burden of proof update that actually rests with the parent or guardian now to determine whether that disability was as a manifestation of the disability. Same idea with isolation and restraint. There's some specific verbiage in IDEA that maintains that any child that is put into an isolated environment, they must be supervised the entire time. If you put a student in a room and walk away, you're breaking the law. Any isolation and restraint must first preserve the dignity of the child, and it can only be used if the safety of that child or others is in question. Isolation and restraint, any expulsion and suspension, any discipline must maintain the dignity of the child first and foremost. So moving into the last kind of couple pieces of this presentation then, we see how IDEA law classifies a child with a disability. So a child with a disability means that any child here is having an intellectual disability, a hearing impairment, including deafness, speech language impairment, visual impairment, serious emotional disturbance, orthopedic impairment, autism, traumatic brain injury, other health impairment, and this is kind of including ADHD, specific learning disabilities, which include dyslexia, deaf blindness, or multiple disabilities, or who, by reason thereof, needs special education and related services. So, highly important here. Your child does not have to have one of these specific disabilities in order to qualify for special education services. Any child who, by reason thereof, needs special education and related services. So we are past this point of assuming that every child with a disability is required to have an IEP, and vice versa. A child with an IEP does not necessarily mean that they're disabled in any one of these disabilities. Section 300.8 of IDEA talks about defining children with a disability and what qualifies them for special education services under IDEA. Colorado kind of builds on that. So the last slide of today then, we have the Exceptional Children's Educational Act that came out in June 2022. This was interesting, and I just wanted to pull this up because it talks more about specific learning disabilities. There is no word dyslexia, dyspraxia, dysgraphia in IDEA. However, state laws have started to adopt it, and there is a Dear Colleague letter that Congress published that encouraged schools, so this is now kind of a federal encouragement, say dyslexia if it's dyslexia, because the term specific learning disability, if it's on an IEP, doesn't really tell you what that child needs. If we get really specific with our specific learning disabilities, that is a much better description of where the child is at and what they need in order to succeed in education. So I thought this was just really interesting that Colorado actually defines specific learning disability much better than IDEA does. So it's a disability that is a disorder in one or more of the basic psychological processes involved in understanding or in using language, spoken or written, that may manifest itself in the imperfect ability to listen, think, speak, read, write, spell, do mathematical equations, including conditions such as perceptual disabilities, brain injury, minimal brain dysfunction, dyslexia, and developmental aphasia. And it also goes into what specific learning disabilities do not include. And it also, I wanted to highlight that it does not include limited English proficiency. So under IDEA, limited English proficient learners will not qualify for special education services based on the fact that they do not speak English natively or fluently. There is a lot of work in Colorado for what we call culturally responsive education, and that includes kind of how to include multi-language learners in the gen ed environment, because that doesn't qualify for them for special education services. It is not considered a disability in any way. And there are other ways where we serve English language learners in schools. And so with that, this presentation went on for a little bit longer than I was expecting. But this brings us to the end. That was just a quick overview of how special education law touches the special education environment. If you would like to learn more, please go to my website. And thank you so much for listening. Catch me on TikTok too at STEM Teachers Staff. I will be on YouTube later. Goodbye.